Welcome back. Seems as time has gone quite quickly since I last saw you. I'm sure you've been busy. For what I've called practice exam papers, but they are actually the exam papers from 2020 and 2021, okay? And they are the main and reset papers for 2020 and 2021. And then tomorrow night we'll do another 4 papers. It's quite a lot of practice exam papers to work through, but because we've just completed the course, I don't really feel like we need to spend any time going back over the substantive content. So I don't want to waste time doing that. But I will do that for the evidence law lectures because it's been so long since we touched on the topic of the evidence law. Okay, so hopefully you have done some preparation in advance. Otherwise, the speed at which we race through these practice exam papers tonight, you're going to find it very difficult to catch up. And I would suggest that you do at least one of these practice exam papers or the ones that we look at tomorrow night under exam conditions, right? So you time yourself with just an hour and a half and you handwrite your answers because that's what you're going to have to replicate in exam conditions. Obviously, like I've been saying to you all along, treat it as a closed book exam, all right? So take in your notes, but have everything in your head rather than sitting there reading. You're going to have an hour and a half. There is no additional reading time for criminal procedure. The time limits for the Crim Pro and the evidence exam are different. For the evidence, you get reading time. For the Crim Pro, you don't. For evidence, it's 2 hours. For Crim Pro, it's an hour and a half. For Crim Pro, there is no choice of questions. You have to answer all questions. For evidence, there are 3 questions, you choose 2, okay? So just be aware of the different time limits and the different rules that apply to each of the different exams. When you get your exam paper, you'll see that it's very much a problem question format. This is a lot more of a practical subject than some of your other more theoretical subjects. So bear that in mind. And of course, you have to do all questions to give yourself the best possible chance of passing. When I mark the exam papers, the students who fail or who have not done well are the ones who've left out questions. Right now, let's say there's 5 questions. If you've only answered 3, you've pretty much left out half of the exam, right? So you're making your chances of passing very slim. So please manage your time effectively. Please, if time is up, when you figured out how long you can devote to each question, move on to the next question and try and pick up some marks quickly on that. Of course, they have to be your own answers, so you can't copy verbatim from the slides or lecture notes or anything. Okay, so with that in mind, let's go ahead and get started. Okay, so we're going to start by looking at practice exam paper 1. So this was, because it's from 2020, actually the time limit was different. The time limit used to be longer, 2 hours, and there used to be 10 minutes of reading time. Right, so that's one thing to bear in mind when you look at the content of the question. So what we have here is we have 18-year-old Jane Learn charged with 2 acts of shop theft. And the prosecution case is that she stole a bottle of shampoo and a bar of soap. A store worker, Elsie Lamb, noticed her secreting them in her bag. Jane left the shop without paying. Lamb alerted another staff member, John, who called the police. 10 minutes later, Jane was stopped on the street by the police, arrested and handcuffed. Her bag was searched. And a bottle of shampoo and a bar of soap found on her was seized. She was then cautioned for suspected theft. The police handcuffed Jane and took her to the Watson's shop. Elsie had gone for lunch, but John told the police he thinks Jane must have been the thief, as he could recognize the shampoo and soap as brands which Watson's keeps in stock. She's taken to a police station where she exercises her right to receive legal advice before answering questions. So the first thing I'd always recommend that you do is read the whole question paper first, right? Read all of the fact pattern, read the questions so that you have a sense of where paper is going, so that you have a sense of what issues to deal with each of the questions. I wouldn't just launch in and start answering question 1 without reading the rest of the paper. Like you can see here, what I've done is I've tried to simulate how I would answer this exam question if I were you, like how I would approach it. So the first thing that I would do is kind of highlight relevant facts that jump out to me as I'm reading through this fact pattern. Okay, so that's what I've done here. I've highlighted the fact that she's 18 years old. And in the comment section, right, I've tried to give you an indication of why that fact is relevant. So for example, the fact that she's 18 years old, that triggers in my mind to think about Section 109A and the provisions that apply to sentencing young offenders. Okay. Next thing that I think is relevant is she's charged with 2 acts of shop theft. Now, what I've said about this is when you read the facts, it's a little bit unusual that she's charged with 2 separate counts of shop theft, right? The allegation is that all of this happened on the same day as part of the same transaction. So yes, she stole 2 items, but usually the prosecution would only charge this as 1 count. So 1 count of shop theft of stealing shampoo and a bar of soap. Now, I didn't draft this exam paper, so I'm just kind of commenting on it. But the fact that it's 2 counts of shop theft, obviously if she's convicted, she has 2 convictions for shop theft, not just 1, right? So that's why that is significant. But I do think it's a bit strange that she's charged with 2 counts rather than 1, okay? The next thing I have highlighted as relevant is the items in question, a bottle of shampoo and a bar of soap. Why is that important? Because we're not talking about high value items here, right? Presumably fairly low in value. That goes to the seriousness of the offense. We have Elsie Lamb notices her putting them in the bag. What is that making me think about? Eyewitness. So perhaps this question is going to go somewhere into the area of identification. About 10 minutes later, she was stopped on the street. So 10 minutes later, my comment on that is she stopped close by only 10 minutes later. So perhaps that's going to their reasons for stopping her, the police. She's stopped on the street by the police. So we need to think about the provisions of Section 54 of the Police Force Ordinance. She was then arrested. So we need to think about, is there a lawful arrest under Section 50, subsection 1A of the Police Force Ordinance without a warrant? She's handcuffed. So was it necessary to handcuff her? Is she resisting arrest? Is there a climate of oppression maybe, if she's going to go on to confess later? Her bag is then searched. Is it a legitimate search? Is the search being done under Section 54 or Section 50, subsection 1A? Her possessions were seized. So is there a power to seize in connection with a lawful arrest? Yes, there is, under Section 50, subsection 6. She's then cautioned, right? Is the caution in accordance with Rule 2 of the Rules and Directions? And then they handcuff her and take her back to the shop. Remember this provision in Section 51, Police Force Ordinance, she should be delivered forthwith to the officer in charge on arrest. So is it legitimate for them to take her back to the shop? Elsie's off for lunch, but John Marr says, Jane must be the thief because I recognize these items as brands which we stole. So in other words, Lamb does not identify Jane immediately after the commission of the offense. And then John's comment, is this speculative? Is it a common brand? He didn't see her steal, right? So that's maybe, I'm just thinking, is John going to give evidence at trial, maybe challenge the weight? So this is just me issue spotting, thinking about potential issues as I read through that fact pattern for the very first time, right? So not all of these points may become relevant as I go on to look at the question, okay? But this is just the issues that would jump out to me if I were you reading this question. Oh, and then also she's exercising her right to legal advice, okay? So question 1 is worth 8 marks, 8 out of 50. So on this time, I've figured out that that gives you about 19 minutes to answer this question for 8 marks. Okay, so comment on the police behavior surrounding her detention. Have they followed correct procedures in their stop, search, and arrest? Okay, so if we think back to our issues, the first thing that we identified was the stop and search provisions under Section 54. So did they have the power to stop her on the street and question her? So to help you in thinking about how to structure your answers, right, I've set it out very clearly for you. Obviously, when you're answering in the exam, you don't put issue in square brackets, law, application to the facts, right? This is just for teaching purposes. So the first issue I want to address is the stop and search provisions under Section 54, right? Then I set out what the law is. You don't need to copy and paste verbatim the whole of the section, just pick out key provisions. So subsection 1, acting suspiciously, and search for anything that may present a danger. When we apply that to the facts, there's no evidence that she's acting suspiciously, right? We're just told that she's close to the scene. So probably they don't have the power to stop and search her under subsection 1. But under subsection 2, they can stop anyone who they reasonably suspect of having committed an offense. Now, we're told that John has called the police, but we don't know why they stop her in particular. Is a description given of the person, the shop thief, to the police? Does she match the description? But she is close by the shop 10 minutes after the call. Okay, so under subsection 2, they can search for anything of value. So applying this to the facts, given that she's close to the shop, if she matches a description that John's given, it's a short time after the call, it's likely that they're justified in stopping and searching her under 54.2. So at the end, we need a conclusion. Lawful to stop and search. Okay, so that's the first issue to deal with. Second issue is under this section, there's no power to arrest and no power to seize. Also no power at common law. So in order for them to arrest her without a warrant, they need to be within section 50 subsection 1A. So they need this reasonable suspicion of guilt for an offense that on first conviction, you can be sentenced to imprisonment. And we know from section 9 of the theft ordinance, this is that type of offense. So when they find the soap and shampoo in her bag, the same type of items that have been reported stolen from the shop, this would give them the reasonable belief or suspicion that they need in order to arrest her under section 50 subsection 1A. But we've also got, related to the arrest, remember, some general principles. So she has to be informed of the reasons for her arrest, Christian Lichinsky, unless she's already aware of the general reasons or it's impractical to do so. And she has to be cautioned. So she would appear to be aware of the reasons for her arrest because she was cautioned by the officers and taken back to the store. She has to be delivered forthwith to the police station, but that doesn't mean immediately. So now applying the law to the facts, likely it's permissible because it's just a short distance away from where she is arrested. So it appears that her arrest is lawful because she would be informed of the reasons for her arrest if she's been cautioned under Rule 2. But there's a couple of other things that we flagged. So now we need to think about whether it's legitimate to search her and seize the items in connection with the arrest. So section 50 subsection 6. They have the power to search her and to seize items which they reasonably believe will be of value to the investigation. When we apply that law to the facts, clearly the shampoo and the soap are of value to the investigation because they are the same type of items alleged to have been stolen, right? So our end conclusion to wrap this up is the search and seizure appear to be lawful, okay? So there's quite a lot to put in here for our 8 marks, right? Because we start off with a general discussion of section 54, applying it to the facts. Then we have to talk about the power of arrest under section 51A. Then we have to talk about the reasons for arrest, the caution, the power to search and seize. Okay, so that's why I'm saying that even though it's open book, you have to be familiar with all of these provisions and the key cases as well. Okay? Any questions about that first part? Fairly straightforward if you know the provisions of section 54 and section 51A, right? Don't forget to apply the law to the facts. So often when I'm marking, I just see a regurgitation, right? I just see a copy and paste job of everything in section 54 and everything in section 51A. That's not being a good lawyer, right? That's not being a good law student, right? Anyone can copy and paste. You need to apply the law to the facts and reach a conclusion. That is the critical part of your answers. All right. Next part, question 2, is worth 22 marks in total, but it's divided up into a number of subsections. So again, the first part is worth 8 marks, right? So if we work on the basis of a 2-hour exam, which it was back then, that gives us 19 minutes. So now we have been called to the police station to advise Jane. Please answer her questions. Must she answer police questions about the incident? So what do we think this question is about? Sorry? Well, the question is, does she have to answer police questions about the incident? Yeah. So it's about, does she have a right of silence? Okay. So we're going to have to, though, for 8 marks, if we just say, no, Jane has a right of silence, I'd give you half a mark for that, honestly. That's so basic and fundamental, right? What else am I going to need for 8 marks? So I'm going to need some case law for sure, because I need to back up what I'm saying with authorities. I'm going to need a discussion of the law about the right of silence. I'm going to need any relevant provisions under the Bill of Rights Ordinance, perhaps, okay? Anything that may be relevant to this right of silence. That's how I'm going to get my 8 marks. So is she obliged to answer questions? Of course, generally not, we know. There's the provision in Article 11 of the Bill of Rights. It's a common law right. It's in the Bill of Rights, but it's also, remember, reflected in the rules and directions, right? Remember Rule 2, you're not obliged to say anything, but if you do say something, it can be taken down and used in evidence against you. That's setting out the whole fundamental principle of the right of silence. So here's the law, and I've given a case as well there. Now, if we apply that to the facts, she was cautioned on arrest and reminded of her right of silence. She's not obliged to answer any questions, and that means that if she stays silent, it cannot be used against her at trial. And once she's charged, then Rule 3 provides that it's only in exceptional circumstances that she can be asked additional questions. That is, if she does not exercise her right of silence, right? If she chooses to speak to the police, they can ask her questions, but once there is enough evidence to charge her, then they should not ask any more prejudicial questions. So what I've put here in the comments is some little reminders for you. There is a difference between cautioning a suspect and charging them, right? When a suspect is cautioned by the police, that should take place at the scene of their arrest, all right? And they should be cautioned in accordance with Rule 2, right? Told what they're being arrested for and reminded about their right to silence. That's a caution. But a charge is different. That is when back at the police station, they are formally charged with the offense and a charge sheet is then drawn up. So there's a distinction between the caution and the charge. And principle, I think it's D of the rules and directions tells us that as soon as there is enough evidence to prefer a charge, the suspect should be immediately charged. And that's when no further prejudicial questions can be asked under Rule 3, unless there are exceptional circumstances. So, conclusion, she does not have to answer the police's questions. And even if she chooses to do so, she should not do so without her lawyer present. Now, there are other things that we could have said generally about the right of silence, right? Because the right of silence extends not just to answering questions from the police, right? But also there's no obligation on her to testify at trial. But I didn't go into that here because the question is asking about, does she have to answer police questions about the incident? So it's clearly directed to this pre-trial right of silence, not about whether she exercises that right at trial, okay, not about whether if she doesn't testify at court, how the judge should direct the jury. Okay, we're just talking about answering police questions. The next question is, Elsie Lamb was at lunch and they want Lamb to have the chance to identify Jane in an ID parade at the police station. Must Jane participate? For 7 marks. So this is a really easy question, in my opinion, because of course, she has no obligation to take part in an ID parade. She doesn't have an obligation to help the police to prove the case or the prosecution. The prosecution has the burden of proof. But practically speaking, it doesn't mean they'll just give up if she doesn't take part in an ID parade. They will try to use some other method of identifying her, which may be more prejudicial in nature. But if she doesn't participate, then failing to participate cannot be used against her at trial, although the prosecution may say that's why we need to try and do a doc identification, because she failed to participate in an ID parade. If she does participate, then of course, as her lawyer, you need to ensure that the ID parade is properly constituted, the right number of actors, that they resemble her general appearance. And overall conclusion, you'd probably advise her that it's in her best interests to take part in the ID parade. You'll be there to make sure the correct procedures are followed, because if she doesn't, the police will use a more prejudicial method of identification like group or confrontation or doc ID. Was it right for the police to handcuff Jane after arresting her? So here we are back again to the lawfulness of the arrest. Now, remember, this is an arrest by a police officer. So we're looking at the provisions of the Police Force Ordinance, all means necessary to effect an arrest. And it's a value judgment. So let's apply it to the facts. Was she resisting arrest? No. It is a relatively minor offense. So was it really necessary to use handcuffs? Also, if there is going to be an issue of identification, right? Let's say Elsie was in the shop and when Jane was taken back to the shop in handcuffs, the officers had said to the person that you saw stealing the items, the fact that of course makes it more likely for her to be identified by Elsie, Okay, so that's just something to bear in mind with a fact pattern relating to handcuffs. But that's not the case here because Elsie's not in the store. John didn't see her stealing the items, but he does say, oh, yes, she must be the thief because these items are what we stock. So, first issue is it lawful to use handcuffs? We conclude probably not necessary here, but what is the effect of it? It's probably unlikely that this alone is going to make her arrest unlawful to the extent that anything seized from her cannot be produced into evidence. But if there is a confession, maybe we can use the use of handcuffs to argue that her confession was involuntary. Maybe if there's a question of identification, we can use it to challenge the weight to the identification. She may be able to lodge a complaint to Capo about the circumstances of her arrest, but it's not going to render the search and seizure of the shampoo and the soap unlawful or those items inadmissible. Okay, so that's question 2. So actually the timing here, I think, is fairly generous, right? Because we have quite a lot of time just to deal with this part. And then we have Jane interviewed by the police in your presence, and she made no admissions. So what's my comment about this? So if she's making no admissions, then there's nothing for us to challenge. There's no confession that we need to challenge and argue it's inadmissible. So there's no need then to think about whether the handcuffs created a climate of oppression, right? So that earlier issue that we potentially flagged disappears, which is why, again, it's important to read through all the questions. She also refused to take part in any ID parade, but we know she's not obliged to, but perhaps we're going to find out they used some other method to identify her. She has one previous conviction for shop theft in 2015, for which she was placed on 12 months probation. So a previous conviction, this is the 2020 exam paper, so that's 5 years old, which timing doesn't seem to make sense because we're told that she's only 18, right? So that means she's 13 when she's convicted. I suppose it's possible, but 12 months probation for a 13-year-old would seem quite harsh. Anyway, but the point of this is to get you to think about on the last occasion she got probation, so the court is more likely to increase the sentence this time on the basis that the previous sentence didn't work. So the case will be tried in the magistrate's court. So we need to be thinking about 2 years as the maximum sentence. But remember what we flagged earlier about there being 2 charges of shop theft. And remember this provision in section 57 of the magistrate's ordinance that allows for a magistrate, when imposing consecutive sentences for 2 convictions, to extend the jurisdiction to 3 years. Okay, so it is possible that she could have a sentence of 3 years imposed on her if she's convicted of the 2 offenses of shop theft, if those sentences are imposed consecutively. At trial, the prosecution proposes to call Elsie in the hope she will identify Jane. So, of course, now we need to think about, is this a doc ID and is it permissible? So those are the clues from this fact pattern. So let's see, we have 10 marks here. So to what extent can a valid objection be made to Lamb seeking to identify Jane in court? Give reasons for your answer. So can she do a doc ID? Generally, under the law, not if it is a first-time identification because it's prejudicial, but there are exceptions. It may be permissible where they're known to each other, where the original circumstances of the ID are good, or where the witness has identified the defendant very soon after the commission of the offense. So if we just stop there and think about it here, are any of those exceptions applicable to Elsie? Does she know Jane beforehand? No. Did she identify her very soon after the commission of the offense? No. So it seems that there's no justification here so far for doing a doc ID. But it may be allowed where she's refused to take part in an ID parade, or it's not practical to hold one. But of course, the judge can still prevent it if the prejudicial effect outweighs its probative value. She didn't have to participate, remember? And it seems like there has been no other form of identification attempted by the police. So when we apply the law, really, they should have used an alternative method to try to identify her rather than just trying to do a doc ID. If no other method of identification was attempted, then on balance, the doc ID is probably more prejudicial than probative and should not be allowed. But if it is allowed, then the weight to be attached to it could still be challenged. Okay? Everyone following so far? So the last question is, she's convicted after trial, sentenced to 3 years imprisonment. She's very upset by her sentence and wants to appeal. Advise Jane whether she should appeal against her sentence. Give reasons for your answer. Outline the procedural steps which should be taken if an appeal is to be pursued, identifying the court to which any appeal would be made, and the time limits for making an appeal. Now, this is quite a long question. What I would do is either using different color highlighters or using numbers, right? Number out the different parts that you need to answer so you don't forget some, right? So the first significant thing is appeal against sentence, right? Don't include in your answer whether she should appeal against conviction. You're totally wasting your time. This question is only asking about an appeal against sentence, right? Okay, second, you need to justify it, of course. Third, procedural steps. We need to identify those. What are we talking about when we talk about procedural steps? What does that mean? What kind of things do you need to include in your answer? Right. Time limits. How long does she have to appeal? What else? Sorry? What do you mean various applications? So what does she need to do? Yes, but what does she need to do? To which court is she going to appeal? What else? Does she need leave to appeal? Right? What particular forms does she need to complete? Right? What are the formalities? Okay? So that's what we mean by the procedural steps. And then identify any court, the time limits, okay? So she was sentenced to 3 years imprisonment. We know that she's in the magistrate's court. Are there good grounds to appeal? Because that's dealing with whether she should appeal, right? So in order to advise whether she should appeal, you need to identify whether she has grounds to appeal her sentence. So in the magistrate's ordinance, section 113, subsection 1 is the relevant provision. And we don't need leave to appeal, and we are appealing to a single judge in the CFI. So that's the law. Now, if you look at 113, it doesn't specify the grounds, but we can use the same general grounds of appeal against sentence as under the CPO. So either it's a sentence that the magistrate could not have passed because it's outside his jurisdiction, or it's wrong in principle. That means the wrong type of sentence was imposed. So she should not have been sentenced to imprisonment. She should have been sentenced to a fine or probation. Manifestly excessive, the sentence was unjustifiably harsh based on a wrong factual premise. That means the wrong facts were taken into consideration, or there's been a change in the tariff. Here, her grounds of appeal would seem to be that the sentence is manifestly excessive and or that it's wrong in principle. Okay, now let's see why I've identified those as the two most relevant grounds of appeal. So let's take wrong in principle first. Why do you think I'm saying that there may be a good ground of appeal on the grounds that it's wrong in principle to send her to jail? Right, so low value items is one relevant fact. What else? She's 18. So remember, way back at the beginning, we flagged 109A that we need to consider, okay, the provision for young offenders. Remember that provides that for an offender under the age of 21, they shouldn't be sentenced to imprisonment unless there's no other alternative. So here we have the provisions of section 109A, right? You don't need to set this out in full. You can summarize it. But remember, it doesn't apply to accepted offenses in Schedule 3. So she's only 18. Theft is not an accepted offense. So 109A should have applied. And the magistrate should not have imprisoned her without first calling for pre-sentencing reports. She does have a previous conviction for theft, but the value of the items is minimal here. So she is a good candidate for a rehabilitative approach, perhaps a longer period of probation, or maybe a community service order, or maybe training center or rehabilitation center. Remember, she can't go to the detention center as a female, possibly even a suspended sentence. But to go from 12 months probation to 3 years for shop theft of how much could we realistically be talking? I mean, even if it's a designer brand of shampoo, $200 max, we're talking about 3 years imprisonment for $200 seems to be wrong in principle. But we can also argue it's manifestly excessive. Now, there's no tariff, but remember that in sentencing, the court is going to look at the circumstances of the offense, how serious it is, what's happened before. So we would expect generally that we kind of work up the sentencing ladder of like fine, probation, community service, suspended sentence, short period of imprisonment, and then the imprisonment gets longer. Maybe if they're a young offender too, we factor in training center, rehabilitation center, okay? So here, it is relevant that she was previously sentenced to 12 months probation. The magistrate can look at that and impose a harsher sentence second time round, but it seems to be manifestly excessive to impose 3 years. Now, we've also got this issue that she was convicted of 2 counts of shop theft, and the sentences could have been imposed consecutively. Now, I've just put in square brackets here because, like I said, I didn't draft this exam paper, but it's not clear how that 3 years was arrived at. Was she sentenced to, let's say, 2 years on charge 1 and 1 year on charge 2, and the sentence for charge 2 was ordered to be served consecutively to charge 1? Okay, that's how we arrive at the max of 3 years. That's legitimate under Section 57 of the Magistrates' Ordinance, assuming that for charge 1, it really is the worst type of shop theft that the Magistrates' Court would be dealing with, which seems unlikely here. But on the other hand, if the magistrate sentenced her to 3 years on charge 1 and 3 years on charge 2, and those sentences run concurrently at the same time, then that would be a good ground of appeal because it would be outside of the jurisdiction of the court. Okay, so I flagged that there because it's not clear on the fact pattern how that sentence of 3 years was arrived at. But in any event, I think we can conclude it's manifestly excessive and she has good grounds of appeal. So yes, were there some questions? Okay. All right. So don't forget the procedure. What is the procedure? It's an appeal from the magistrate's court, so she has to appeal within 14 days. No reference to clear days, so time period starts to run on the day of her sentence. Extension of time is possible, and the CFI has the power to increase or decrease her sentence. She has to file notice in writing signed by herself using Form 102. Okay, so that's just the procedure, which is very straightforward. And we've already said she doesn't need leave to appeal. She's appealing to the CFI. What else might be relevant under procedure? If we have time, we could briefly mention she can apply for bail pending appeal to a magistrate under 1191A or to a judge in the CFI under 122. Does her appeal have substantial merits? Would a substantial part be served before the appeal was heard? Overriding consideration, does the appeal have substantial merits? So here we would conclude she does have good merits in her appeal. She should apply for bail pending appeal. But of course, whether she should apply for bail pending appeal or not depends on the type of sentence she's received, right? If she's got a non-custodial sentence, obviously you don't need to apply for bail pending appeal. But here she's been sentenced to imprisonment. So unless you apply for bail, she'll be remanded until her appeal is resolved. Okay? Any questions for the first paper? Okay. So let's move on to paper 2. This is the resit in 2020. So it is still 2 hours, 10 minutes, which is not your scenario. So here you represent Brian Tack and Ben So, charged with robbery, contrary to section 10. Tack is 15, So is 18. So I've highlighted that. Of course, their age is irrelevant. The police say that a lady, Madam Sum, around midnight, went to the ATM, withdrew $20,000, put the money in her bag. A man then grabbed at her bag and $10,000 fell out. Another man pushed her down, took the money, and they ran away. She broke her wrist and was extremely frightened. She screamed, and a policeman saw Tack and So running down the street and stopped them. They were arrested for robbery. The $10,000 which was stolen was then recovered. They were then interviewed separately. After waiting for 2 hours, Tack was interviewed by 2 policemen. No one else was present during the interview. Why have I highlighted that in particular? Why are we being told no one else was present during Tack's interview? He's only 15. So we need to think about that provision of the rules and directions, that if the suspect is under the age of 16, they should have their parent or guardian present during the interview, unless there's good reasons to deny. Under caution, he denied the offense and said he's mistakenly arrested. One of the policemen then tells him there's no point in his denying he robbed the lady because So has confessed and named Tack as his accomplice. The officer then shows Tack a confession statement signed by So, which implicates Tack. Tack then admits the offense. Okay. So question 1, comment on the police behavior in the interview. Can Tack challenge his confession? How would he make such a challenge? Okay. So again, I think we need to separate this out into different parts. We've got to talk about what the police have done that they shouldn't have done. We've got to think about the law relating to the admissibility of a confession. We've got to think about the procedure for how he goes about and challenges the confession. So I would start with a general introduction to the law. Of course, Principle E, Ibrahim Ping Lin. It's important to say that the burden of proof is on the prosecution to prove the voluntariness of the confession beyond reasonable doubt. First issue, is it voluntary? But even if it is found to be, first issue, is it involuntary? But even if it's found to be voluntary, the court can exclude it in the exercise of their residual discretion. But if the court finds that a confession has been made voluntarily to a person in authority, it's rare for them to exercise that residual discretion. But with residual discretion, we're talking about unfairness in the way it was obtained or unfair to use it at trial, prejudicial effect outweighing probative value, or substantial breaches of the rules and directions. And then we've got the two-stage objective and subjective test in Chow Ching K that we can set out as well. Is there any conduct on the part of the person in authority that's capable of amounting to an inducement? And if so, did it actually influence the mind of the accused? So what I'm doing here is just summarizing from your lecture notes, okay? So this is all in your material already. We also need to establish that the officers are clearly people in authority under the test in Dio Kananen. They have control over the defendant, over the investigation against him. So that's the law bit, okay? The next bit is the application, okay? Now, I haven't set it all out for you in like little steps like I did with the first, okay? But it's the same structure that we're following, right? Identify the issue, what is the law, apply it to the facts, conclude. Same procedure, okay? So what are we going to argue here? Go back to our fact pattern, because we're going to keep referring back as we work through. So for TAC, we have this issue that the policeman said, So's confessed and named you as an accomplice. So there's no point you denying it. Then they showed TAC the statement implicating TAC. So how does that go to the issue of voluntariness? Is it a threat or inducement sufficient to render the confession involuntary? Remember, we also need to think about causation, right? And the issue of dissipation. Because if there's been a long time period between the misconduct and the making of the confession, it's possible that it didn't influence him to confess. Causation has been broken. We also have the issue about the fact that he's only 15 years old. That goes to a breach of the rules and directions. Direction 5. So far as practicable, he should have had a parent or guardian present with him. So applying it to the facts, there seems to be no reason why they couldn't delay the interview until they could locate his parent. They've got both of the suspects in custody, TAC and So there's no issue about other people still being at large. They've recovered the stolen property, so there's no issue there. So when we apply the law to the facts, I think we can conclude there's a good argument that the confession was involuntary because of threats inducement. But even if it's voluntary, we have this breach, a very serious breach of Direction 5. We also have Rule 6, right, which says that they can show TAC So's statement, but nothing should be said or done to invite any reply or comment. And then if the person does say something in response, they should be immediately cautioned in accordance with Rule 3. This is basically a rule of evidence. What A says against B out of court cannot be used in evidence against B, only as evidence against A. So they can show TAC the statement, but they should not have commented that So's already confessed and implicated TAC. And it also appears that TAC was not cautioned. Now, in our fact pattern, we're told that he's left waiting for 2 hours before he's interviewed. So maybe you would be thinking, is that oppressive? Probably not. 2 hours is not a significantly long period of time. But that does give us justification for arguing that in that 2 hours, they could have located his parents and invited them to attend the interview. So it appears here, our conclusion, that they is a good ground to argue involuntariness and also substantial breaches of the rules and directions. Now we have to think about the procedure, because going back to our question, how would he make such a challenge? So he can either use the voir dire or the alternative procedure. Remember, voir dires are possible in all levels of court. This is robbery, of course, so it's a serious offense, but it's still likely maybe the district court. So we're thinking about the alternative procedure. And when that happens, the special issue of the admissibility of the confession is dealt with in the course of the evidence. There isn't a separate trial to consider the issue of admissibility. Okay, so that's it for question 1. Question 2. Tack and So both decide to plead not guilty and are due to make their second appearance before the magistrate tomorrow. Advise them where their case is most likely to be heard and why. So you were given a copy of section 10 in the exam paper. So you would be able to identify by reading that section that it's an indictable offense and that the maximum is life imprisonment. Now, we're told that they're charged with robbery, so that's what we're proceeding on. But I just put a little note here for you to think about, because there is a difference between robbery and theft by snatching. Theft by snatching is a much less serious offense than robbery. But here they've used force against the victim. She's pushed to the ground and she sustained some injuries. So that's why they're charged with robbery. But when we're thinking about the venue, remember we need to look at part 1 of the second schedule. And we see there that it's carved out. It's an indictable offense punishable with life imprisonment, but in brackets it says except an offense against section 10. So what that means is that robbery can be tried in all 3 venues, and that the prosecution are going to decide on the venue based on the seriousness of the offense and the likely venue. If they decide to proceed in the magistrate's court, then they need to consent to it, section 94A of the magistrate's ordinance. In your lecture notes, you have that case where the magistrate tried to force the prosecution to take plea in the magistrate's court for a robbery offense. And on appeal, that was held to be outside of his jurisdiction, because it's the prosecution that decide on the venue, not the court. The way that they consent is by asking for plea to be taken in the magistrate's court. Now, in your notes on sentencing, I've given you the tariffs for kind of the key offenses. So in your lecture 6 notes, you have tariffs for robbery. Mo Kwang Sang, the tariff for armed robbery, and what we mean by armed robbery is a knife or a dangerous weapon rather than a gun. The starting point is 5 years after trial. But for unarmed robbery, there isn't actually a tariff. Now, here on this fact pattern, is it armed robbery or unarmed? It's unarmed, right? Because they just push her to the ground. But there are aggravating features, right, in the fact pattern. It occurs late at night. It's out in public. There's violence. They push her to the ground. She breaks her wrist. It's a large amount of money, $10,000. Yes, at the end of the day, it's recovered. It's not like they voluntarily hand it back, okay? So likely starting point is probably around 3 to 4 years. And I just put some cases for you here. So that means that the district court is probably the most likely venue for So. How old is So? 18. Tack is 15. So is an adult. He's 18. TAC, though, is only 15. So he appears to fall within the jurisdiction of the juvenile court. Remember, the juvenile court hears offenses against offenders under the age of 16. But there's a complication with Section 3C of the Juvenile Offenders Ordinance. If it's a summary offense, then the juvenile court has exclusive jurisdiction over summary offenses, except where a juvenile is charged jointly with an adult. Now, robbery is not a summary offense. Robbery is an indictable offense. So for indictable offenses, the juvenile court only has what we call concurrent jurisdiction. That means that he could be tried in the district court or in the CFI, as well as in the juvenile court. So because of the seriousness of the offense, it's more likely that he would be charged or tried, with SO in the district court, rather than separately in the juvenile court. SO can't be tried in the juvenile court. He's too old. Okay, now technically, TAC could be tried in the juvenile court because he's under 16, and SO could be tried in the district court. But that would be very unsatisfactory because you would have two trials taking up a lot of time and cost. And then what if you get two separate results? What if one's convicted and the other's acquitted? You'd have a disparity. So generally, in that situation, TAC will be tried alongside SO in the district court. But remember, if he's convicted, then the other court shall remit the case to the juvenile court for sentencing, Section 3F of the Juvenile Offenders Ordinance. Now, this last bullet point I put in, because again, I have a little bit of confusion on the facts. We're told here, essentially, that the lawyer is representing TAC and SO. But to me, that doesn't make a lot of sense, because when we look back at the fact pattern, we're told TAC denies, I've been mistakenly arrested. SO, on the other hand, says, yes, I did it. TAC was my accomplice. So they appear to be running inconsistent defenses. So as a counsel, you would never represent two clients who are running different defenses, like one's blaming the other and one's denying all involvement, right? It would be a huge conflict of interest. So I'm not sure why on the fact pattern it's drafted like this. But I left it in, right? Because it was a previous exam paper, and also because it gives us good points for discussion. Case has been listed for trial in 2 weeks. Prosecution has sent a formal request to you to agree to Madam's son not being present. She wants to go to a friend's wedding in China. The prosecution requests that you permit her statement to be tendered to the court as evidence pursuant to Section 65B. Now, I think we can predict what the next question is going to say, right? For your defense counsel, are you going to agree to this Section 65B request? No, she is the key witness. She's the star from the prosecution's perspective. She is the victim of the robbery. If there is no evidence from her, the prosecution's case is significantly weaker. So as defense counsel, you would want to cross-examine her, especially since TAC's defense is, I didn't do it, I was mistakenly identified or mistakenly arrested, right? Should you agree, give reasons, 16 marks. So we start off with a summary of what 65B is. It's an agreement for the written statement to go into evidence. It's treated as if the witness had orally testified to the contents, but there's formalities to comply with. There has to be a declaration of truth in it, has to be signed by the witness. And if it goes in under 65B, then likely she's not coming to court to testify unless you ask the court for leave for her to come. But that's not a guarantee because you're asking the court for leave. And the court's not going to give you leave if you say, well, yes, we shouldn't have agreed to this going in under 65B, we've changed our minds. You need to have a good reason why her attendance is required. If the statement goes in, you can still contradict the contents, but remember, in practice, you'd never agree to omit a statement that you want to challenge the contents. It doesn't make sense. So she's the victim. You would want to challenge her evidence, possibly her identification. You would want to cross-examine her. You'd never agree to admit the key witness's statement under 65B. There's no obligation on you to agree the prosecution's request. I mean, so she wants to go to her friend's wedding. Well, too bad for her and her friend. It's not the defense's problem. It's the prosecution's problem. So you have to object within 14 days. Otherwise, the statement is admitted into evidence. Now, here, of course, the prosecution would issue a witness summons to Madam's son. You don't need to put this in your answer, but I'm just putting it here for you for your revision purposes, right? So the prosecutor would issue a witness summons to her, which compels her attendance. And if she doesn't attend, then she could be imprisoned for up to 2 years. She can be arrested and brought before the court. So, of course, the prosecutor needs to tell her of her legal responsibility to attend if a summons is issued, right? But I think more practically, they would impress upon her how important her evidence is to the case, right? And you would say things like, well, you've been the victim of a very serious crime. Do you really want these people to go free and be allowed to commit robberies on other people, right? So rather than threatening her with the issue of the witness summons straight out of the gate, right? Try and make her feel how important her evidence is. Now, again, I've just put some options for you here about the possibilities of what the prosecutor can do if you have a witness who is going to be overseas at the time. So you could make a 65B request, but it depends on whether the other side will agree. There is the provision for testimony outside of Hong Kong by live TV link under 79I, but you need leave of the court. And the court won't give that leave if the evidence can be more conveniently given in Hong Kong, not just because she's tripped off overseas to a friend's wedding. You could apply for an adjournment, but there will be cost consequences, apply to withdraw, or consider offering no evidence. So you don't need to deal with that here, but that's just for background revision purposes. And then the last part is they're convicted after trial. Both were sentenced to 4 years imprisonment. Tak is unhappy. He wants to appeal. So we are only advising Tak. We are only advising on an appeal against sentence. We need to think about which court we're appealing to, what grounds we have, and does he have good grounds of appeal? So if we assume that he's tried in the district court because it's robbery, it's serious, then he would appeal to the Court of Appeal. He needs leave. He has 28 days from the date of his sentence. He can apply for an extension. Time starts to run on the day after his sentence, and he uses Form 11. Possible grounds: wrong in principle, manifestly excessive. Read the question carefully. I can't remember if it was last year or the year before, but one of the questions was asking students to advise on appealing either conviction or sentence. And quite a few students just didn't read the question properly and advised on the wrong appeal, right? So advising here only on an appeal against sentence. Don't put in anything about an appeal against conviction, because that's not what you're asked to do. Powers of the court on appeal: they could impose a more serious sentence up to the maximum jurisdiction of the district court. They can also order a loss of time for an unmeritorious appeal, Section 83W. But if there's good grounds of appeal, that's unlikely. They have the power to admit fresh evidence on appeal, and the Court of Appeal can grant bail pending appeal. Remember, the district court cannot grant bail pending appeal. There's no statutory basis for it to do so. Does he have good grounds of appeal? Tak is only 15. So should 109A have applied? But robbery is an accepted offense under Schedule 3. So that's different from Jane's shop theft, which was not accepted. Robbery is accepted. So that means that actually Section 109A does not apply to TAC. There is no obligation for the court to call for pre-sentencing reports, but he's still a juvenile. So he would ordinarily be remitted to the juvenile court for sentencing under Section 3F of the Juvenile Offenders Ordinance. And then Section 11, Juvenile Offenders Ordinance. No young person shall be sentenced to imprisonment if he can be suitably dealt with in any other way. But robbery is serious, so it probably merits some kind of custodial sentence. So perhaps the court would adjourn to call for training center, detention center, or rehabilitation center reports. So that would mean a 2-week adjournment. So you could argue that the imprisonment is wrong in principle, given his age. But remember that the guidelines are around 3 to 4 years for an unarmed robbery, but he is only 15. Manifestly excessive. Here, it's significant that TAC and So got the same sentence. So's 18, he also got 3 years. So that makes TAC's 3 years seem manifestly excessive. Should his age have been taken into account as a mitigating factor? It's not extremely young, but when So has been given the same sentence, it makes TAC seem manifestly excessive. So I think the conclusion is here, good grounds of appeal against sentence. It was wrong in principle, manifestly excessive. Okay? See, we have whizzed through 2 papers in an hour and 10 minutes-ish. You can do it, right? You can. Any questions on practice exam paper 2? No? Now is your time to ask questions tonight and tomorrow, because once we have finished the revision lectures, I'm not going to answer individual questions sent to me by email because it's not fair to the group as a whole. So if you have questions, now's the time to ask. Yes. The question is, would the exam structure be similar? It will be a fact pattern. Sometimes it's a large fact pattern. Sometimes it's individual, broken into individual sections, right? But yeah, it's going to be similar in nature. Yes, you had a question? Not if it's not in your notes. I'm not going to ask you about anything that's not in your notes. You may get a different type of offense that we haven't talked about, but if so, I'll give you the provisions of the offense, or I'll say you don't need the provisions of the offense for the purposes of this question, okay? So I'm not trying to trick you by giving you something unexpected that you don't know about, right? If it's an unusual type of offense, then I'll either give you the section or I will say it doesn't matter for the purposes of this question. Okay? Yes? No? So I put that in for you just as a kind of thing to consider. I think in question 1, did I? Was it question 2? Yeah. You don't need to think about whether it's theft by snatching or robbery. I'm just flagging it for you to think about in other scenarios. Here they're charged with robbery, so that's what you focus on, robbery. Don't talk about other offenses because it's not relevant. Okay, so let's take a 15-minute break, 10-minute break, between 10 and 15 minutes. Come back just after 8:30, okay? And we'll go through the other. You can see here now, this is the 2021 exam paper, practice exam paper 3. This is the same format as you will have. 1.5 hours, no separate reading time. I don't know why they cut the exam time. I don't know why there is a different format for evidence versus Crim Pro. Like in evidence, you can choose your questions here. You can't. I don't know. It's not up to me. I just follow what I'm told to do. What you'll have to do. Okay. Just a couple of questions on the chat. First, when talking about an appeal under Section 113, do we have to cover all the relevant provisions, e.g., the court of first instance can grant a rehearing or the powers? I think you have to look at the mark allocation. You have to be selective. You have to bear in mind your time. The answer is really, it depends what the question is, right? But certainly look at the mark allocation and focus on the key points. Do you need to write an overall introduction and conclusion? It's not an essay, right? You need to actually apply the law to the facts and give conclusions and answer the question. Due to the time issue, could we write some abbreviations? I'll give you a list of acceptable abbreviations in tomorrow night's lecture, I think. Since we will bring your lecture notes to the exam, how can we use them but not copy from them? I don't know how to answer that question other than to say, don't copy from them, right? It's a bit like when you read a textbook, right? You absorb the knowledge and then give it back in your own words. Okay. All right, practice 3. Your client, Ahmed Sami, age 20, is an asylum seeker charged with robbery contrary to Section 10, maximum life imprisonment. He's said to have robbed a man, John, eating dinner in the barbecue area. Someone came up behind John, held a knife to his throat, demanded his wallet. Doris, his wife, had left and didn't see the offense. He handed over his wallet, quickly looked around, saw a man with a knife running away. Man was tall and thin, with short dark hair, wearing a blue jacket with the print of a yellow star. He had his back to John. John could not see his face. He called the police and they intercepted a man matching the description John gave a few blocks away. That's Sani. Sani was carrying a knife measuring 17 centimeters in length with a serrated blade when he was stopped and searched. He made no admissions to the police. He says it's mistaken ID. He tells you he had the knife with him for protection. He's not guilty. Okay, so again, just highlighting some key things I'd want to think about as I'm reading through these questions. So I think I can tell from these facts where this question is going. It's going to be something about identification. There's going to be something about his sentence for robbery, given his age. So question 1, he's interviewed, he makes no admissions. The police now want to conduct an ID parade to see if John can identify Sani. Need he participate? What are the consequences and risks? So in 2021, if you looked at the exam paper last year, the previous year, this was a bit of a gift question because we're back to ID parades again. But this question is a little bit of an expansion because it says, what are the consequences and risks if he fails to do so? So we would start off with the same points that we've already talked about for the last exam paper, but it means that they will use some other method of ID. Okay, so we've already covered all of this on this first slide. We've covered a little bit about what the disadvantage is of not going into an ID parade. He's not obliged to participate, but because this is worth 20 marks, we want to give a little bit more detail here. So if he does decide to participate, the lawyer would need to make sure all of the correct procedures are followed, 8 actors of similar weight, height, appearance, no opportunity for them to see him before the parade. We have an independent officer supervising the parade. His lawyer is present, etc. Okay? So that is easy question for you guys for 20 marks. He's due to make his first appearance in the magistrate's court next week. What is likely to happen and where his case will probably be tried? So on his first appearance, is the prosecution likely to have decided on the venue for the trial? Is the prosecution likely to ask for plea to be taken? No. So we need to talk about that, but we also need to talk about what is the likely venue based on his sentence, based on his offense. So same things we talked about before: indictable offense, life imprisonment, all three levels of court, because it is excluded by parts 1 and part 3. So it's an indictable offense that can be triable summarily, up to the prosecution to decide. This time it's an armed robbery with a knife. So Tariff and Mo Kwang Sang, 5 years imprisonment. It would be outside the sentencing range of the magistrate, so likely venue is district court. He's 20, remember, so juvenile court not appropriate. What does that mean? The magistrate cannot refuse the transfer request because it's an indictable offense under section 88(1)(a). So they make the application orally or in writing. They hand the papers and the transfer order. Plea is not taken in the magistrate's court, only in the district court. But the magistrate will tell Sani when to appear in the district court, given the alibi warning. But as we know, they won't be ready to proceed on his first appearance. So they're likely to ask for an adjournment of up to 6 weeks. And then that means that the question of bail needs to be considered. But bail is unlikely here because of the seriousness of the offense. So what's going to happen, it's likely that he will be remanded in custody until the next hearing, and then they will apply to transfer the case to the district court. Okay, that's where our 20 marks would come from. So for this one, you need to know really the tariff so that that helps you to decide on the likely venue. Question 3, he participates in the ID parade and John identifies him as the robber. At trial, the prosecutor want the court to allow John to confirm that the man in the dock, Sani, was the man who robbed him. Should the judge permit this application? So this is a question about doc ID, right? Because that's essentially what John's being asked to do. Now, some of you I could see were shaking their heads when we said, should the doc ID be allowed? But remember, a doc ID is only impermissible, only prejudicial, if it is a first-time identification. Is this a first-time identification in the doc? No. Why not? He identified him in the ID parade. If he had failed to identify him in the ID parade and then was being asked to identify him in the doc at trial, that would be a first-time prejudicial identification. But he positively identified him in the ID parade. Now, at trial, John is being asked to confirm that the person in the dock is the person he identified in the ID parade. So this falls within the exception in Christie. We already have a good identification. He's just being asked to confirm it. Should the judge permit his application? So the students who just said, no, it's a doc ID, cannot be allowed, probably would have got some marks if they cited an authority, but you're not going to get anywhere close to the full marks because you haven't done the full proper analysis. Okay, so first 2 bullet points, that's just repeating what we said on previous exam papers, but here it's permissible. It's just confirming an earlier identification. If there is any doubt about John's identification, if, say, for instance, John can't remember who he identified, or let's say he can't remember what position Sani was in when he made the identification, then you could call the OC parade who could testify as to the fact that Sani was identified during the ID parade. And if there's a video recording of the ID parade, which there usually is, the video of the ID parade can also be played as well. Okay. So here, yes, doc ID would be permissible. John would be allowed to do it. Sani has now been convicted after trial. He's been in Hong Kong for 12 months as an asylum seeker. The judge used his status as an asylum seeker to enhance Sani's sentence and ordered him to serve 7 years imprisonment. Sani has no previous convictions and is very worried about going to jail. Would you advise him to appeal his sentence? Now, to be honest, I think this is the only difficult part of this exam paper, right? Because if we think about the 2 exam papers that have gone previously, right, it's kind of same kind of issues coming up. But I didn't write this paper either. Do not assume with the papers that I write, there's going to be the same kind of issues coming up, okay? Because here we can see it's another appeal just against sentence. But there are some different points here, some complications. What's the relevancy of the fact that he's an asylum seeker? So they're probably like a Form 8 holder, which means that they cannot work in Hong Kong as one of the conditions of being given this Form 8. And so basically they are here at the discretion, the liberty of the Hong Kong government. So it's an aggravating factor. If they are convicted of an offense, which a lot of Form 8 holders do end up committing offenses because they're in a bit of a catch-22 situation. They can't work, so they can't earn money, but the amount of money they're given to survive by the government is not sufficient. So what do? They end up either taking on illegal employment, and then they get caught and then they get deported because they have breached the terms of their Form 8, or they commit offenses to get money, right? And then they get deported. So it's a horribly impossible situation for these people to be in, but that is the reality. But the significance of it here is that the courts view it as an aggravating factor because they want to impose a deterrent sentence. They don't want people to think it's okay to come to Hong Kong, be here living off the government and commit offenses. So they enhance the sentence as an aggravating factor. But here we're told that he gets 7 years. The offense, remember, is robbery. Okay, so starting point is 5 years. Okay, Mo Kwang Sang, and he's got no previous convictions. Okay, so these are relevant things for us to think about. Would you advise him to appeal? So he can appeal against the sentence, same points as before. Mo Kwang Sang, 5 years. Not a straitjacket. The court can depart from it, but usually the tariff would be followed, or the guideline. He's only 20. Does 109A apply? Well, no, because it's an accepted offense. So he's unlikely to be able to argue it's wrong in principle. Now, remember for Tak, who was 15, we did argue that for robbery, we did argue that imprisonment was wrong in principle. But there's a significant difference between 15, he's a juvenile, and 20, he's an adult. Right, so that's why here we're arguing, or we can't argue that the sentence is wrong in principle, given Mo Kwang Sang. But was it manifestly excessive? He's 20, so he's not young enough to get any discount for his exceptional youth. The fact that he's got a clear record as well is not a mitigating factor. It's just neutral. And then we've got some cases on the aggravating nature of being an asylum seeker or a Form 8. So both of these cases, your notes. Mahabul Alam Khan, his sentence was enhanced for the serious aggravating factor of committing a serious crime in Hong Kong, which affects Hong Kong's reputation in the community at large while being permitted to remain in Hong Kong at his liberty. So his sentence was enhanced by 15 months off a sentence of around 12 years. Here, Junaid Ahmed, enhancement of 3 months for the fact that he was a refugee. So in other words, if we take 5 years as a starting point for robbery after trial, we do expect there to be some enhancement for the fact that he's an asylum seeker. But we've gone from 5 years to 2 years, right? Which is almost half of the sentence. So based on these cases, it would seem that the enhancement is manifestly excessive. Here I've just summarized for you in the blue what we mean by a Form 8 recognizance holder or a non-refoulement claimant. So an additional 2 years appears to be manifestly excessive. So yes, he should appeal his sentence. And then the last bit is the procedural part. Which court would hear the appeal? Which procedures? What is the power of that court? 20 marks. So you're going to see here the same points that we have covered already. Leave, single judge in the Court of Appeal, 28 days, file Form 11, sign it by Sani, starts to run the day after sentence was passed. Powers of the Court on Appeal, quash the sentence and impose any sentence available within the jurisdiction of the district court. Warn Sani of the risk his sentence could be increased on appeal, but that's unlikely because we've already said his sentence is manifestly excessive. Warn him if the appeal is without merit, he could suffer a loss of time. That loss of time provision means that any time that he's spent on remand between the filing of the appeal and the hearing of the appeal would not be counted in calculating his release date. If his appeal is unmeritorious, he would lose the benefit of that time. But that's also unlikely here because he has good grounds of appeal. Powers to admit fresh evidence, power to grant bail pending appeal. District court can't do it. But here, I think this is a key conclusion to reach. He's only appealing his sentence. And we can't argue that imprisonment was wrong in principle. So there's really no point for him to apply for bail pending appeal, right? Because if we take Mo Kwang Sang as 5 years, and we are arguing that his sentence was manifestly excessive, but we're looking at some discount from 7 to around 5, right? With a bit of enhancement. We're not looking to reduce from 7 down to a couple of months, are we? So if he does get bail pending appeal, what's the point? If he's successful in his appeal against sentence, he's going to have to go back into custody. He may as well stay in custody, and then the time that he serves will count towards his release date. Okay, so just practically thinking about it, there's no point applying for bail pending appeal here. Be different if he was appealing his conviction. We had good grounds to appeal his conviction, then the sentence would disappear. But where you're just appealing sentence and it's a very long sentence, there's no point to apply for bail pending appeal, even if it's technically possible and he has good grounds of appeal. Okay, any questions for Sani? No? Okay. Now, hold on a second. Practice exam paper 3 was online. I think that was COVID eras, right? 2021. That's why. But by the time we got to practice paper 4, this is the reset. This is August 2021. Obviously, we're having a little bit of a break in the restrictions, and this was actually done in person. So it was handwritten, in other words. Yours is going to be in person, so you've got to be handwriting. So we have Jenny Wu, Hong Kong resident, age 15, charged with obtaining property by deception, essentially a serious type of theft offense, right? Section 17. Mrs. Wong age 59, in the market, was approached by a young girl alleged to be Jenny, who said she could see bad luck all around her. She introduced her to a miracle healer named Sun. Sun, a 45-year-old man from mainland China, told Mrs. Wong that she would continue to encounter bad luck unless she agreed to a spiritual blessing. She would need to provide Jenny and Sun with valuables, which she would get back afterwards. She went home and got her life savings of 207,000 from under her bed, as well as a gold necklace. Now, it amazes me the number of people in Hong Kong who appear to keep hundreds of thousands of dollars just lying around in their house. Maybe that's just because I personally never have any cash in my wallet. So my husband has to pay for everything, but that's deliberate on my part. But I don't know, maybe amongst the elder generation in Hong Kong, there's a real distrust of banks. But the number of people who have significant amounts of money who you wouldn't normally consider to be very well off, I find it quite staggering in Hong Kong. Right. But it happens all the time in Hong Kong. And certainly when we read the papers these days, right, we see so many of these scam type of offenses where people are being duped out of millions of dollars that they're just kind of transferring online. Anyway, so she goes, gets the money and the valuables, then it's put inside a bag, take it home, don't look in it tomorrow. So she goes to bed very happy, opens the bag, realizes it's full of rocks or something, and reports the case to the police. Jenny and Sun were by Mrs. Wong from CCTV footage. Jenny was arrested in the market the following day. Immigration travel records show that Sun entered Hong Kong via Lo Wu on the 22nd of December 2020. Now, why are these dates significant, right? We need to think about, remember, be suspicious, right? Why are we being given the dates here? The offense happens on the 23rd of December. He's come into Hong Kong on the 22nd. What's the significance of that? He only had to pay for one night in a hotel. Is that the relevancy? What do you think is the relevancy of it? Right. He's come to Hong Kong to commit this offense, is the relevancy. So that's going to be an aggravating factor. All right. You're given this section here. So we see it's an indictable offense, liable on conviction or indictment to imprisonment for 10 years. Okay. Did Hong Kong police have the power to arrest Jenny and Sun to prosecute them for this offense? If they're tried, what would be the likely venue of trial? Now, what do we think? Do they have the power to prosecute Jenny? She's 15. Yeah, because she's 15, right? What if she was 5? No, right? Because remember the age of criminal responsibility, thinking back to our evidence, which we're soon going to revise. Children under the age of 10 cannot be prosecuted. They're under the age of criminal responsibility. But she's 15. She's a Hong Kong resident. Sun is from China. Can the Hong Kong police or charge Sun with an offense? Yes, because it was committed within the jurisdiction of Hong Kong. So that's just kind of a simple couple of lines at the beginning. I think most of this question really is directed to what's the likely venue for trial. Okay, so yes, power to arrest under our general provisions. Under the age of 10, no child can be liable. It's a conclusive presumption, cannot be rebutted. Section 3. Power of arrest at common law without a warrant under Section 50, subsection 1A. No requirement for them to be a Hong Kong resident. No requirement for the officer to see the offense being committed. Was there a reasonable belief Jenny and Sun would be charged with an arrestable offense? or is there a reasonable suspicion of guilt? So here, because the question is talking about the power to arrest, we obviously want to go into section 50, subsection 1A. We have the leading case of Youngmei 1, reasonable belief on the basis of a reasonable suspicion, looking at circumstances or events which caused or created the reasonable suspicion. So it's a subjective and objective test. Genuine suspicion on objectively reasonable grounds. They were identified. So that's the law. Now we apply the facts. They were identified by the alleged victim from CCTV footage. Jenny was arrested close to the alleged crime following the identification. Son was arrested after they checked the immigration records. So it seems that they did have the power to arrest Jenny and Son. The appropriate venue for trial, it's an indictable offense. I would make sure that you have parts 1 and part 3 of the second schedule in the exam, right? If you have to answer a question on venue, but it's in your lecture notes already. So it's not excluded because it's not a maximum of life imprisonment. So it can be tried in all 3 venues, up to the prosecution to decide. Now, there isn't actually a tariff for obtaining property by deception because it can be committed in a wide variety of circumstances, and there's a wide range of the seriousness of this offense. But the usual sentence is imprisonment. Now, in your lecture notes, when I've dealt with, in lecture 5, some cases on sentencing, under the aggravating factors section, I've put in what we see is basically from the year 2000 onwards, a lot of cases of these kind of scam deceptions, street deceptions, tonic medicine kind of cases. And what these authorities say is that there can be an enhancement of up to 50% for these kind of street deception cases. And there's also the possibility of OSCO. Remember the Organized and Serious Crimes Ordinance. There can be an enhancement under OSCO. So what's the appropriate venue for the trial? For Son, he's an adult, so the district court is the likely venue. You can see here this case, starting point of 3 years. That's, and then there's a 1/3 reduction for the guilty plea. Totality principle, 50% enhancement. Jenny is aged 15 though, so she is a young person. And in this case, it's not robbery, it's obtaining property by deception. So it's an indictable offense, but it's likely that she would be tried together in the district court with Son. So the likely venue for them both is district court. So this is very similar to what we said before for tack and sew with the robbery. I'll change that in the, it's not robbery, it's, I've just basically copied and pasted in from the earlier slide. That's why I've made that error. Okay, question 2. Jenny is about to be interviewed at the police station. Can she have her mother present? This is easy because we already know this. Direction 5. So far as practicable. She's only 15. But remember, these are guidelines for the police to follow. But if they don't follow this, then it is a serious breach which could render her confession inadmissible. A young person's parent can be excluded in certain circumstances where the delay would mean valuable evidence would be lost, or perhaps other offenders would be able to escape. But here, there's nothing to suggest that Jenny's mother couldn't be located and attend. So yes, she should be entitled to have her mother present. So 14 marks is just basically a discussion of direction 5 and an application of that to the facts here. Oh, another question about ID parades and the consequences. Ugh. So let's just see. I don't think there's anything in these next slides that we haven't already covered. I'll change that in the, it's not robbery, it's, I've just basically copied and pasted in from the earlier slide. That's why I've made that error. Okay, question 3. Jenny is about to be interviewed at the police station. Can she have her mother present? This is easy because we already know this. Direction 5. So Jenny did not take part in the ID parade. She's now being tried together with Sun. During the trial, Mrs. Wong identifies Jenny from the witness box. Should the judge take this identification into account? It's doc ID again. So, blah, 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 nothing here. Now, here I've just set out the law, okay, on this slide. Here are some things for us to take into account. The fact pattern tells us that Mrs. Wong identified Jenny and Sun from CCTV footage. So does that mean that the doc ID is not a first-time identification, right? Merely a confirmation of an earlier identification. But to me, it seems quite strange that she would identify them from CCTV footage, unless she already knows them, right? But it's not clear, and there was no comment in the marking guide about the CCTV footage. So we don't know actually whether the CCTV footage was actually admitted at trial. And we have no information on the quality of the CCTV footage. Usually CCTV footage is of pretty poor quality, actually. So even if it is admitted, could we challenge the weight to be attached to it? So I suspect that when the person was drafting this question, they actually didn't intend for the ID evidence from the CCTV footage to be part of the marking guide. So that's why there's nothing in it. So really what they're talking about here is whether she can do a doc ID. And if she has made an earlier positive identification, she can do the doc ID. And also where there's CCTV footage, then either the judge or the jury, depending who's the fact finder, they can be asked to view that footage and then compare the likeness of what they see in the footage or in the video evidence with the defendant in the doc. That's also a possibility. Another issue here, which wasn't in the marking guide, was if the identification does go into evidence, then of course we might want to think about Turnbull and challenging the weight to be attached to that evidence, particularly where it's ID evidence from CCTV footage and that is of poor quality, then there may be an issue about the weight to be attached to it. And it's not clear here if Jenny is claiming mistaken identity in her defense. Remember, Turnbull only goes to the weight to be attached to identification evidence that's admissible, number one, and only where that identification evidence is an issue in the case. In other words, the defendant is running a defense of mistaken ID. But I think because there's no real information on Jenny's defense, here, that's why there's no need to address Turnbull. But just bear it in mind, if there is a challenge to the identification evidence, then you may need to consider Turnbull. So I think the facts of this are a little bit unclear here. It's not clear to me how Mrs. Wong was able to identify Jenny and Sun, because unless she knew Jenny, she might be able to look at the CCTV footage and said, yes, that's the girl who tricked me. But it still doesn't follow from that how Jenny ends up being arrested if they don't know who Jenny is. So anyway, it's just a side point. What are the sentencing considerations for a young offender that the court will need to be mindful of if Jenny is convicted? So this question, I think, involves a bit more consideration of the Juvenile Offenders Ordinance and the different sentencing options. So as a starting point, Section 11, no young person should be sentenced to imprisonment if there is a suitable option. Thought I already muted everyone. Maybe some new people have joined. Section 15, there are various other options available for young offenders. So there's a much wider discretion in the juvenile court to sentence young offenders. So we have the options of like a remand home or a reformatory school. We have what's called a care and protection order. We have the fact that young person's parents can be ordered to pay a fine. We have the possibility of an admonition. That's basically just like a telling off and a discharge. But that wouldn't be appropriate here for Jenny because this is a serious offense. And we have the option of a training center or rehabilitation center for Jenny. Don't fall into the trap of discussing detention center because she's a female. Yes. With this question, I think you can mention Section 109A CPO because it's not an accepted offense. So yes, you could add that in as well. I will put that in the notes. That is a good point. I think I didn't put it in here because I was putting in Section 11, which is basically the same principle. But yes, you should probably, for completeness, also put in Section 109A. So likely that the court will adjourn sentencing to call for pre-sentencing reports. There may also be a report from the Young Offender Assessment Panel, which would give advice on suitable sentences. Because of the seriousness of this offense, she may be sentenced to a training center or rehabilitation center. But it's quite likely that if she is tried in the district court along with her co-defendant's son, then the case will be remitted to the juvenile court for sentencing under Section 3F. And then the last part, can the court enhance Jenny's sentence under OSCO? So I set out relevant provisions of OSCO for you in your notes for Lecture 6 in quite some detail. But if we look at Schedule 1, which again, I copied and pasted out for you, Section 17 is a specified offense, which means that the sentence can be enhanced under OSCO. But we said also the street deception is an aggravating factor. So what the court needs to be careful of here is that it doesn't doubly count the same fact. In other words, if the court enhances sentence, adopts a higher starting point, in other words, under OSCO, because it's a specified offense, then they shouldn't also treat it as an aggravating factor to adopt a higher starting point, because that would be plus plus for the same point, okay? Now, here's the significance of the timing of his entry, son, into Hong Kong, right? Just one day before the offense was committed, it makes it likely that this was a planned offense. But in order to be an organized crime, we have to be talking about 2 or more acts. So it's unlikely that the prosecution would seek to have this declared an organized crime. So remember, under OSCO, there's 2 levels. There's an enhancement for a specified offense, which Section 17 is, but there's an additional enhancement if it's also an organized crime. Now here, it's 2 or more people working together to commit an offense, so it meets part of it, but it has to be 2 or more acts. So it's not an organized crime, it's just a specified offense. So there can be that first level of enhancement. But if we have earlier concluded she's likely to get training center or rehabilitation center, then the question of enhancement becomes irrelevant, because you don't get your sentence, the length of time in the training center or rehab center, enhanced under OSCO. You only get your sentence of imprisonment enhanced. So if the court sends her to training center or rehabilitation center, we wouldn't enhance it under OSCO. Because remember, for DC, TC, RC, DATC, how long they spend there is not up to the judge. It's up to the Commissioner for Correctional Services. And it depends on their performance inside the center. So all the court does is say, I sentence you to the training center. It does not impose a length of time in that center. But she could be subject to provision release from the training center. And if she goes to the rehabilitation center, it's a mandatory post-supervision release. Okay. Tomorrow night, we are going to look at 4 exam papers, but those ones will take us a lot more time to get through than these 4 because the same issues, tonight we saw the same kind of issues just come up repeatedly. With the papers that we look at tomorrow night, 2023 and 2024, I believe they're all ones that I drafted. So you'll see the issues are not the same. Sometimes they're similar issues, right? Sometimes they're different, but you don't see the same kind of repetition that you see with all of these papers. Okay. So we are going to finish early tonight, but that is very deliberate, is I want you to spend that time really preparing your answers to these exam papers. Because tomorrow is our last revision lecture. I plan to do a lot less talking than I did tonight. Tonight was a bit cruisy for you. I didn't ask you many questions, kind of went through my slides, gave you a lot of the answers. Tomorrow night, I'd really like you to put yourself in the best possible position to pass the exam by being fully prepared. At least, if you don't have time to do one under exam conditions, at least read through all the papers, jot down bullet points. Think about how you're going to get the marks for the question. Okay. All right. So before we finish for tonight, are there any questions? Nope. Okay. See you tomorrow.